So the last presentation is done by Juyeon Lee. Dr. Lee completed her PhD in social and behavioral health sciences from the Dalla Lana School of Public Health at the University of Toronto. And her researches focus on health and safety consequences related to digital labor platforms for domestic workers and engage in caregiving tasks. She's currently postdoctoral fellow at the University of Waterloo.
So good morning and thank you for joining me today. And my presentation will share preliminary findings of my work to re-theorize the findings of my PhD thesis, which explores the historical development of occupational health and safety regulation in South Korea. So today I will focus on a movement to criminalize work-related death, particularly highlighting the enactment of the Serious Accident Punishment Act, SAPA, in 2021 in South Korea, often referred to as the corporate killing law. This legislation is groundbreaking as it reclassifies workplace injuries and death as criminal offenses, reframing these tragedies as more than a mere regulatory violation. The act imposes a penalty of imprisonment for more than 1 year or a fine of up to 1 million Canadian dollars on corporate directors or business owners for injuries and death of employees, not only employees, but also their subcontracted workers. It's important to note that South Korea's experience is part of a larger international movement aimed at holding corporations criminally accountable for work-related death. And this trend is particularly evident in neoliberal states such as Canada, the United Kingdom, and the United States, where similar legislative measures were implemented ahead of Korea. So existing critical studies often suggest that the movement to criminalize work-related death is a direct consequence of the failure to effectively regulate workplace safety and health. And the central question driving my presentation today is that regulatory failure does not automatically lead to radical responses, such as the criminalization of work-related death. And this is evident in South Korea, where political actors have only recently begun to address these failure with significant legislative action. And today, I will discuss the specific conditions under which regulatory failure escalates into a legitimation crisis, prompting social actors to recognize this failure as unjust and mobilized for structural change. And this categorization of administrative and legitimation crisis was originally developed by a German social theorist, Jürgen Habermas, and further expanded by American critical theorist and feminist Nancy Fraser. And Nancy Fraser really emphasizes the role of counter-hegemony in politically mediating the translation from administrative into legitimation crisis. And Fraser offers a framework to understand the crucial political mediation that bridges regulatory failure and legitimation crisis, and counter-hegemonic struggle, actively challenge prevailing social norms and power dynamics, working to create new understanding of social reality, what Fraser called a new political common sense. So, however, as she acknowledges, not all oppositional practices are inherently counter-hegemonic. An individual isolated act of resistance may not have the power to ignite widespread social transformation. And Danny Filk, in his recent article, expands on this idea by proposing 3 key parameters that help us identify when resistance can truly be considered a part of a counter-hegemonic struggle. So first, the extent to which the oppositional practices is incorporated or tolerated by a hegemonic model. And second, whether the resistance challenges both symbolic and material dimension of the hegemonic model. And third, whether the resistance produces a collective political subject, enabling organized forms of collective action. The findings of my research will, which I will explain shortly, provide empirical evidence that confirm this theoretical account. So to provide some context, South Korea's historical trajectory differs significantly from that of Canada and other advanced capitalist economies. So it was marked by a growth-first ideology under authoritarian rule that violently repressed and excluded labor and took a residual approach to social security. The democratization in 1987 offered a glimmer of hope for change, but the Asian financial crisis of 1997 abruptly ushered in a wave of neoliberal reform in the country. A striking aspect of the underdevelopment of occupational health and safety regulation in South Korea is the relative apathy of the union movement. This can be attributed in part to the structure of union organization or collective bargaining, which occurs primarily at the enterprise level rather than at the industrial or national level. So as a result, enterprise level unions often prioritize maintaining harmonious relationship with their employer counterparts, sometimes at the expense of advocating for broader occupational health and safety concerns that affect workers beyond their immediate membership. The combined effect of government inaction and employer exploitation and limited union engagement has resulted in a concerning concentration of workplace death in small businesses, as well as recurring serious accidents within larger establishments with a disproportionate impact on subcontracted workers. So in the face of widespread apathy from organized labor, a grassroots social movement emerged outside the mainstream union structure in South Korea. So since 2003, this movement has been tirelessly advocating for the introduction of a corporate killing law. From 2006 onwards, they initiated naming and shaming campaigns, publicly exposing the companies with the highest number of worker deaths each year, combining employees and subcontracted workers. And while these efforts have not made big headlines, they kind of represented a critical turning point in the discourse surrounding workplace death. They introduced the term corporate killing to emphasize that these deaths are not isolated incidents, but the result of systemic practices of corporations that prioritize profit over safety. And this deliberate use of a morally charged language aimed at spark public outreach and ignite a broader social movement against workplace injuries and death. Despite a decade of dedicated efforts, to be honest, the campaign to enact a corporate killing law hadn't gained significant traction and remaining largely as an idea or a slogan. It was only through the unification of diverse groups and interests that the social movement gained real political traction. A crucial catalyst for this change was the devastating Sewol ferry disaster in 2014, which claimed the lives of over 300 people, primarily high school students. This tragedy spurred labor activists to broaden the movement's scope beyond worker death to encompass the death of ordinary citizens caused by corporate negligence. And the Korean Confederation of Trade Unions took the lead in forging a labor civic alliance, which drafted a concrete law designed to exert economic pressure on corporations. And this move went beyond challenging the symbolic dimension of the hegemony, and it aimed to dismantle the material structure that perpetuated unsafe practice. And this table illustrates the formation of a collective political entity, contrasting the participating organization in the naming and shaming campaigns in 2006 with those in the Labor Civic Coalition established in 2015. And the image on the left shows families of the Sewol ferry victims demanding the passage of the Serious Accident Corporate Punishment Act, and the image on the top right captures a mass rally where thousands of members of the Korean Confederation of Trade Unions gather in an unprecedented show of solidarity for improved occupational health and safety regulation, and for the first time actually in history. So in conclusion, my research demonstrates that regulatory failure alone do not automatically trigger widespread public outcry or demands for change. Instead, it is through political mediation that these failures are reinterpreted by the public as unjust and ultimately leading to a legitimation crisis. The movement in South Korea underscored the need for coordination and collaboration between diverse actors and interests to transform individual grievances into a broader social movement capable of effectively challenging the dominant hegemony and advocating for a structural change. In this process, the Korean Confederation of Trade Unions played a pivotal role by transitioning from symbolic protest to concrete legislative action that exerted economic pressure on corporations. They successfully challenged the material dimension of this hegemony. However, the true impact of regulatory laws lies as much in their enforcement as in their creation. While the effectiveness of the new Serious Accident Punishment Act is yet to be fully assessed, there are troubling signs that the movement to criminalize workplace death is being co-opted by the dominant neoliberal model. The recent legislative election in Korea, where Progressive Party failed to secure a single seat, have removed a crucial source of political momentum for the movement. So this further strengthened the established bipartisan hegemony of two pro-business parties, potentially limiting the transformative potential of the new act in Korea. So thank you very much so this is part of my PhD thesis. Yeah, and thank you very much for your attention, and I'm looking forward to your question. Thank you.
Okay, thank you.